Hello, everybody. I better not be muted. We do exist. The channel didn't get taken down, just the video from earlier, which is what this 13 XXX is in the second video we watched, which I don't even know if the video got to that point, but it was 13 correct, 3 wrong. We were in second place. But that was from the last video, guessing pregnancies, who was pregnant, who was not, and different things like that. So now I'm going to just let everybody know how lonely I am, because, I like to talk. Well, hello, Snow Wonder. I have not seen you in a while. Glad to have you there. Thank you, South Florida Grifter, for the thumbnail. I just needed something quick. Hello, Great Grand X. Hello, Bruce. All right. So it was like as soon as I went offline and I just kept recording. So I guess StreamYard has the full video. YouTube just doesn't, of everything. It's hard to pay attention to all that cut stuff because right now I'm just working off of one screen, which kind of sucks. So, but if you're here, please hit the like button, subscribe. If you don't want to miss a video, turn those notification bells on. I do give times when I am going to stream or when I'm going live on Twitter as well. And if you think you're subscribed, just check and make sure you're still subscribed. YouTube does like to unsubscribe people. And if you want to join us on members, our first members video will be coming in the next few weeks. And it is going to talk about my son and his journey with a young version of a Laura Owens like person. And so that's going to be what we do over on the members. Yes, end of the year stuff with kiddos is so much. My daughter went to one of her friends' graduations today, and they had all the things. So, but as soon as I got done with that last live, I checked and we have new documents. So I was like, all right, let me eat, do some things, and then we'll go live again. Also, there is going to be a live coming up in June on True Crime and Wine Time. That is coming up in June. I will be joining them. It will be on June 13th, and it is going to be 12 p.m. Eastern Standard Time, and it's going to be a 12-hour telethon, GoFundMe for Mike. So it is going to be a mega stream, and you can also follow them on Twitter at TCWT Media. And so that is something that you can look forward to. And then I should have had this other thing. All right. So here is which I just messaged somebody the other day and was like, I wish we got these little reports that they share with the judge that we don't get to see in court, because it's always like, okay, when's the next hearing that we can have? All right, everything in the report looks great. Well, I love people on my replay crew too. I love my live crew as well. But so we have the little report. And what's interesting in this report is, there we go. I could make it a little bit bigger, but not much bigger. That didn't really make it any bigger, but it says, this was from the hearing date, May 20th, so yesterday, Judge Reuter, that defendant has 0 active cases for probation. It says list specific progress made since the last complex management conference in completing activities previously established by the court and the parties. It says plea agreement proffered. Defense continues to review the discovery and collect mitigation. You're going to be trying to collect mitigation for a long time. Probably even after this case, because there's not a whole lot of mitigation. She's an animal lover. There's the mitigation. Specific case preparation to be completed before the next complex case management conference is set settlement conference, and if no resolution, prepare for trial. So could be a change of plea where she's going to accept the plea deal, or it could be prepare for trial, which, since it's extended to June 26th, and then they're going to have the next hearing on June 29th, my brother's birthday. It says witness who have been interviewed since the last court proceeding, none. So the defense hasn't talked to anybody, as far as I know, like by saying none. And witnesses who will be interviewed before the next court hearing, unknown. So they're just working on this plea stuff and looking at discovery. This attorney doesn't seem like he's done any prep work for trial. And we're supposed to go to court basically a month after this next court hearing, because it's supposed to start like the end of July, and she's supposed to possibly accept or not accept the plea deal by then. So that's interesting. It makes me think that there's possibility that it's not going in July. But the judge keeps talking about this hard end date for this criminal case. And I don't know why it's such a hard end date for this case when those deadlines aren't so hard on other criminal charges, because those get extended and extended and extended. So it's just interesting to know. Status of and plans for settlement discussions. It says will set within the next 30 to 45 days, which they did. And status of discovery and disclosures, including whether any remains outstanding. If so, the efforts that are being made to complete the same. And it says discovery and disclosure is complete, which is great, because we've seen in this case that discovery was handed over immediately. They're like, here is everything. Like, we're ready to rock and roll on this if she wants to. Where we see in a lot of trials, if you watch trials where there's just a fight for discovery, they haven't handed over this. They're not handing this over. We need a motion to compel because they're not giving it over. So at least we have this district attorney's office and these prosecutors have handed over all the evidence, because If you have a strong case, which you shouldn't hide the ball anyways, but in a strong case, you're like, yeah, sure, here's everything. I don't have a reason to hide shit from you because you should believe in your case that much. And it's the rules and the law. It says, however, there is a minor issue with a portion of the disclosure, and the defense and the state are working to resolve it. So I don't know if they can't open something or what the problem is there, but they're working on it. And it says any substantive motions that are contemplated and the anticipated filing of such motions, and they say not at this time. Which, if they're going to go to trial, the defense is going to need to file motions in limine, as well as the state could. So the viability of the current trial schedule, current trial date is unrealistic from the defendant's perspective, which that's what I think as well. There's no pending issues to be resolved at this time, and victims' rights have been complied with as applicable. So I guess they have been talking to the victims in this case. Now, whether the victims are actually satisfied or not is a different story. Okay. Somebody came looking for the puppy dog, and I had to let them know where the puppy dog was because she snuck into my son's room. All right. And then it just gives the attorneys and stuff that are on record for this. So that is hello, no thanks, I'm gay. Hello, Texas Packet. You have the dog. You better not have stolen her. I went looking for her everywhere because she was supposed to be with my daughter because I was streaming and I didn't want a grunty pig in the microphone. And then I went searching for her, and my daughter was like, no, I opened his door for a second, so she must have snuck in there. And so and he's not home. He wasn't home at the time. And so I'm like I'm on the floor with like the phone flashlight, like seeing, cause she goes and lays under his bed, and that's her safe, happy place in there. And so I'm like, where is she? Okay. Oh, you have a boxer. Well, I consider her my mother-in-law still, but my ex-mother-in-law, she had a boxer, as well, and he was just the sweetest. Oh, you're fine. Welcome, Cracked Pepper. Okay. So that's the little docket update thing from yesterday that, from Laura. Yeah, and the boxer did not realize he was, a big dog. He thought he was tiny, and he thought he was a lap dog. His name was, Spanky Doodle. Yeah, I'm a lonely single mother here. We can be friends. All right. So then stuff dropped in. Yes, Spanky. He was white. Then some stuff dropped in Gingras's thing, which Rob got us that last update on Laura. So thanks, hey Rob, for that. And then I don't know where we got these updates on the disciplinary thing. I don't know if Hey Rob got these or if Gingras put them out with a blog. Have not looked. So I'm not necessarily going to look at his motion to dismiss, because I think we already looked at that. That was filed May 4th. And we kind of know what he was arguing, what Mark Randazza was arguing. which was that the disciplinary case must be dismissed because the state bar's complaint is barred by Arizona's anti-SLAPP statute, asserting the bar targeted him for constitutionally protected speech, criticizing its actions. He contends the bar acted within proper retaliatory motive, failed to meet its burden under ARS 12751, and that recent court rulings, such as State v. Coert, confirm the statute's applicability and constitutionality, requiring dismissal once a prima facie showing of retaliatory prosecution is made. And I don't believe that this is retaliatory. I don't know why Jim would need, or the Arizona bar would need to retaliate against Gingras. There's no proof of that nonsense. State v. Court case that he is citing, it has to do with Arizona's anti-SLAPP statute in a criminal context, raising significant questions about free speech rights and prosecutorial discretion. And had to do with pro-Palestine protest at Arizona State University's Tempe campus. I don't think that has anything to do, or anything to do with a disciplinary case with the bar, because yeah, you're allowed to protest and say things, and you cannot go to jail for it. You can lose jobs, lose licenses, be civilly sued for certain things. You just can't go to jail for it. So this criminal citing makes no sense to me. But usually there's cases that he cites that don't go through it. Oh yes, I'm supposed to say, this looks bad for Gingras. I apparently do that a lot. All right. So the next one we're going to look at is his request for judicial notice. It's only a few pages, and he wants the court to take judicial notice of things. So we're going to look at that, and then we're going to go into the state bar's brief addressing the applicability of ARS 12751 to lawyer disciplinary proceedings that was filed, and then the state bar's response to respondents' request for judicial notice, comment 8 to ER 3.3. Those last two were filed on May 15th. So this first one is filed on May 7th, 2026. And that's what we're going to look at first. He is such a foolio. Yep. Oh, so bad. Did I miss something? You deal with the daughter. That's fine. Because, yeah, I get that. All right. I didn't share. Well, let me share the screen. All right. And we're going to make it bigger. Howdy ho, Miss Tony Marie. All right. All right, that increased in size, and then I am needing to change my layout. There we go. All right. wonder if I can edit this. Can I make... No, it won't let me make it any bigger. All right, so let's just make this bigger. All right. Request for judicial notice and before the presiding disciplinary judge. Yes, Laura is playing games still. She got it pushed. And a month before the trial, making everyone work towards both options. Exactly. But I don't know that her defense is working towards both options because I don't think they've had time to, because they're still looking at discovery. And the amount of discovery just because of text messages alone is insane. All right. So Lopez is the disciplinary clerk. But here we go, before the PDJ. So he says to support his position either at trial and or in a pending dispositive motion pursuant to the Arizona Rules of Evidence 201C2, respondent David S. Gingras, respondent or Gingras, respectfully asks the court to take notice of the following court records. In the matter of petition to amend Rule 42, ERs 1.6 and 3.3, Rules of the Supreme Court. Supreme Court number, petitioner, things, filed January 10th, 2025, attached as Exhibit A. And Arizona Supreme Court order numbered, filed August 27th, 2025, attached as Exhibit B. He has to do what's in the best interest of his client. He cannot be, because I think the public defender probably tried to talk her into a plea. I think any defense person that she hires should be talking to her in taking a plea because it is the best outcome for her. And she's going to have a problem finding somebody that is not going to try to tell her to take the plea deal. And eventually it's like, okay, if you don't want to take the plea deal, then we'll go to trial. But if he doesn't want to do this and take it to trial for certain reasons, then that's his choice. It's all right, Colorado Canadian. Hello, I like justice. So petition number and the Supreme Court's order granting the petition bear directly on State Bar's legal position in this case. Specifically, multiple claims in this case are based on the Bar's legal assertion that respondent had a duty to diligently investigate and research everything that Owens told him or provided to him. And that was in his amended complaint, paragraph 17. The Bar's allegation regarding the duty to diligence investigate are direct misstatements of the law as explained by the author of the petition. This Chief Justice of Arizona Supreme Court, the Honorable Robert Brutinello, in that petition, Chief Justice Brutinello explained the then current state of the law as follows. Existing rules of professional conduct prohibit a lawyer from knowingly misleading the court or offering evidence the lawyer knows to be false, and restrict a lawyer from alluding to any matter that the lawyer does not reasonably believe will be supported by admissible evidence. However, The existing ethical rules do not require a lawyer to inquire or investigate the authenticity of the evidence before presenting the evidence to the tribunal, even if the lawyer reasonably believes the evidence has been materially altered or generated with the intent to deceive. So maybe this underlined rule hasn't been there. But you, as her lawyer, should know that the shit she was saying and doing is not reasonably believed to be supported by evidence. There is no evidence admissible that supports her claims and her lies. So I still think you lose on that. Or I think you did a bad job. Now, does the bar have to see it that way? Maybe not. But to me, I just don't see how you believe just because she said so. It says existing ethical rules do not require a lawyer to investigate or take any affirmative steps to learn whether the proffered evidence is authentic or whether it has been digitally forged. In fact, ER 3.3, Comment 8 implies that a lawyer is permitted to request admission of evidence even if the lawyer reasonably believes the evidence is false, providing that a lawyer reasonably believes that evidence is false does not preclude its presentation to the trier of fact. So you can just submit false evidence that you reasonably believe is false. You can just present that. That doesn't seem correct or ethical. Like, but I don't think you had a reasonable belief that any of this shit was true. You knew about her patient portal for planned pregnancy, whatever, Planned Parenthood. You knew that when things like that were done, she hadn't been to any of the fucking Planned Parenthoods. You saw her patient portal. Now, do you want to play dumb or blissfully be ignorant? Maybe. Be like, well, I didn't know that Planned Parenthood portal showed like all of the Planned Parenthoods. It could just show that particular location. So where it says she didn't go to that one, I could see that. But I didn't know that one showed every Planned Parenthood. Why didn't she show you Los Angeles and she just says the shit on the stand? And even to this day, she didn't go to Los Angeles Planned Parenthood. But you still want to believe her and back up that she believes she's pregnant or she did go and get an ultrasound, which she didn't. And you have not come out to say, you know what, guys, you're right. She didn't go. Because admitting that JFC is correct about something when it doesn't like help you is something you can't do. The only reason you're doing this one is because Bruce and Patrick pointed something out to you and it helped you. Or you think it helps you. We'll see if it does. So that's the only reason you're like, oh, look, JFC could be right about this. Where are you from? I like Justice McAnany New. Yes, he was told over and over. He didn't care. He wants to just act like he doesn't know. Oh, okay. She's from Hawaii, I'm guessing. Y'all might have just become best friends, Bruce. Although I don't know that best friends want the other dead. Okay, East Hawaii. Very cool. I agree. Yeah, it to me sounded like she was running on it politically, and then when it actually came down to it, she decided she wasn't gonna do a whole lot of shit, which makes me lose a little bit of respect for Rachel Mitchell. Hello, Minnie. Girl, I am that way when I take my meds too. So he only will listen to JFC when it, like, helps him. But he's always like, "Oh, they're liars, they're wrong, but we're also right." It just doesn't make any sense. So, given the Chief Justice observation about the rule not imposing a duty to investigate the authority of the evidence, petition number was drafted to recommend a revision to comment 8 of ER 3.3 as set forth in the appendix to provide that a lawyer who reasonably believes evidence has been materially altered or generated with the intent to deceive has an affirmative obligation of reasonable inquiry before submitting the evidence in court. Mm. So that petition was filed on January 10th, 2025, 7 months after the trial in Owens v. Eckert. The Arizona Supreme Court granted the petition on August 27, 2025, with an effect date of January 1st, 2026. So therefore, when Owens v. Eckert was going on, this whole rule was not in effect then. So it shouldn't have applied to him then, which it should have been a rule. Guess I'm glad that it's a rule now, but these are things that could possibly let him get away with things that for him not doing a good job by blindly believing and just thinking that everybody else that doesn't believe is a cult or a Taliban. These filings demonstrate the state bar's assertion that respondent had a duty to diligently investigate and research everything that Owens told him or provided him materially misstates the law as it existed at the time of the conduct, giving rise to this matter. To the extent the state bar seeks to impose punishment based on retroactive application of the new change, which occurred after the conduct at issue in this case, that position violates ARS 1244, providing no statute is retroactive unless expressly declared therein. And it doesn't say it's retroactive. And also violates ex post facto clauses of the Arizona and U.S. Constitution. He cites some case law explaining the Arizona and federal ex post facto clause provide no ex post facto law shall ever be enacted. No state shall pass any ex post facto law. Signed Gingras. Certificate of Service. Exhibit A. This is the petition to amend Rule 42 ERs 1.16 and 3.3 rules of the Supreme Court. So, pursuant to Rule 28, the rules of the Arizona Supreme Court, when it files the petition on behalf of the Arizona Steering Committee on Artificial Intelligence and Courts Committee, to respectfully petition this court to amend ER 1.16, declining or terminating representation, and ER 3.3, candor towards the tribunal. Comment 8, to ensure sufficient guidelines exist to help lawyers avoid improper presentation of digitally forged evidence to the court. So this is about AI and how AI is a problem. So the existing ethical rule when Gingras was doing this case do not require a lawyer to investigate or take any affirmative steps to learn whether proffered evidence is authentic or whether it has been digitally forged. Comment 8 implies that a lawyer is permitted to request admission of evidence, even if the lawyer reasonably believes the evidence is false, providing that the lawyer's reasonable belief that the evidence is false not preclude its presentation. The drafters of the Comment 8 understandably intend to place the onus for resolving disputes regarding authenticity and reliability in the hands of the judge, or disputes regarding weight in the hands of the jury, and thus drafted language that permitted a lawyer to offer evidence even if the lawyer reasonably believed that evidence was false. However, given concerns regarding the presentation of deepfake evidence, the risk of inaccurate decisions, and the erosion of public's faith in the authenticity of admitted evidence. But to me, you're still not supposed to submit things that you knew were false. And I think this is where the state and Gingras are going to disagree, because I don't think the state bar is saying that Gingras reasonably believed or reasonably didn't believe things to be true or false. And Gingras, to me, didn't submit necessarily what he thought was digitally false evidence. Now, I think the belly pictures that to me have been altered a little bit, or is her burrito belly, that might be a different one. But as far as her saying she got an ultrasound somewhere she didn't, that has nothing to do with 3.3. Because that's just allowing your client to say false things that you know aren't true. It has nothing to do with anything that you believe could be fake evidence or not. And don't give me this shit that you think that she was correcting the record, or how do I know that this wasn't the correct statement because what she said at this point was false, and then what she said at this point was false, but I thought she was correcting the record when she was at trial. The state bar is saying you knew she was lying, plain and simple. And you had a duty then to correct the record. And I think that if he is allowed to submit things with a reasonable belief, even if they are false, that he can still present them to the trier of fact. Arizona should have updated its laws a lot sooner. But the good news is the state bar responds to this shit. But Could Gingras have a decent argument about he was allowed to do that? And he didn't break any rules because the investigating part rule came after the Owens v. Eckerd case was tried. He was warned. That's why I don't think it's a reasonable belief. But it also says, even if you reasonably believe it is false, I think he had a concrete knowing things were not true. He just wants to play ignorant. All right. Let's see. I don't think that's the one I'm wanting. Let's see here. All right. This is going to be the state's response. Yep, he did. But I think he thinks Corey Keith is a little bitch. I'm sorry that you're dealing with that, Snow Wonder. I deal with the tantrums during the day with the grandson when he is not. But at night, no. Well, we're here if you need to vent. Girl, you need to talk, just message me. Correct. If he suspects she will lie, he cannot let her testify. Right. You cannot put your client on the stand knowing she is about to lie. But do I think that Laura even told him she was going to say it was at a different Planned Parenthood? Maybe, because they seem to talk about stuff. So maybe she said a different one, or maybe she just made that shit up on the fly and he didn't know she was going to say that. I don't know. I don't have proof for either way. All right. Okay. So this is the State Bar's response to respondents' request for judicial notice to comments 8 to ER 3.3. So they're going to discuss this shit. With the PDJ before the presiding disciplinary judge. So it says, let me get a drink real quick. The State Bar of Arizona, by undersigned Bar Council, hereby responds to respondents' request for judicial notice of a petition to amend ERs 1.6 and 3.3. Supreme Court petition filed by Justice Brudenell on behalf of the Arizona Steering Committee on Artificial Intelligence and the courts, and orders subsequently entered by the Supreme Court. The State Bar objects to the presiding disciplinary judge of the Supreme Court of Arizona, the PDJ, taking judicial notice of the petition to amend comment 8. Okay. Why don't they want him looking at it? Or why don't they want the judge looking at it? Or 2 ER 3.3, because judicial notice may be taken only of adjudicative facts, not legislative facts. Rule 201A, Arizona Rules of Evidence. Adjudicated facts are simply the facts of the particular case. Legislative facts, on the other hand, are those which have relevance to legal reasoning and the lawmaking process, whether in the formulation of a legal principle or ruling by a judge or a court, or in the enactment of a legislative body. Federal Rules of Evidence, Notes of Advisory Committee Committee on Proposed Rules, see footnote 1. The Arizona Supreme Court amended many of the rules of evidence to conform to the federal rules of evidence. Prefatory comment to the 2012 amendments to the Arizona Rules of Evidence. Evidence Rule 201 now mirrors the federal rule. In State v. Weingartner, 2018, the Arizona Supreme Court stated, when an Arizona evidentiary rule mirrors the corresponding federal rule, we look to the federal law for guidance. Although the federal court's interpretation of the federal rules of evidence does not control our interpretation of our own evidentiary rules, federal precedent is particularly persuasive given that we have expressly sought to conform our rules to the federal rules. Citations omitted. All right. Courts across the country, so state to state, from California all the way to DC, all across the country, have defined legislative facts differently. See United States v. Gold. 8th Circuit, 1976, defining legislative facts as established truths, facts, or pronouncements that do not change from case to case, but apply universally. Jungian versus City of Oxford, a 5th Circuit 1983 case, deeming a fact legislative because it turns on social factors and happenings which may submit to some partial empirical solution, but is likely to remain subject to opinion and reasoning. United States versus Bellow, a 1st Circuit 1999. So we're getting all the circuits, hitting it up. 1, 5, 7, 9. All the things. Whether a fact is adjudicative or legislative depends not on the nature of the fact, but rather on the use of it, i.e., whether it is a fact germane to what happened in the case or a fact useful in formulating common law policy or interpreting a statute. 6th Circuit case, legislative facts involve generalized factual propositions, while adjudicative facts relate to and are determinative of one individual's situation of course of conduct. Moving on over to D. Mont 2017. So District of Montana, I guess. Plaintiffs asked the court to take judicial notice of several federal and Montana statutes, regulations, and published court decisions. But because these statute cases and regulations are legislative facts rather than adjudicative facts, they are not appropriate for judicial notice. Arguments made by a single person, or in this case, a committee, in support of the adoption or interpretation of a particular rule or law is not a legislative fact. Undersigned counsel has found no Arizona case specifically addressing the meaning of legislative fact, as that term is used in Evidence Rule 201. Neither has counsel located any case finding that someone's interpretation of a rule amounts to a legislative fact. In addition, the current comment 8 to ER 3.3 was not applicable at the time of respondent's conduct. The amendment to Rule 201 based on Justice Brutinel's petition did not become effective until January 1st, 2026. Respondent's conduct occurred in 2024. So the state bar is like, yes, he is correct about conduct happening in 2024 and the new rule coming into effect January of 2026. Based on the foregoing, the State Bar moves the PDJ to deny respondents' request for judicial notice regarding the recent amendments to Common 8 to Evidence Rule 201. I think she can just take judicial notice of the filing. I don't know if she needs to. So, adjudicative facts are the specific facts involving an illegal dispute. They focus on the particulars of a case, such as who did what, when, and how. Adjudicative facts are established through evidence presented during a trial, including witness testimony and physical evidence. So basically, like a personal injury case, the details of an accident and the extent of the injuries would be considered adjudicative facts. Whereas legislative facts that inform the legislative process and judicial reasoning, that's a broader scope and relate to social, economic, or political context surrounding the law. Legislative facts help a court understand the implications of law and that are not tied to specifics of a particular case. For example, in cases like Brown v. Board of Education, the Supreme Court relied on legislative facts to assess the societal effect of segregation. Says legislative facts are general and provide context for understanding the law, while adjudicative facts are specific to the case at hand. Adjudicative facts must be proven through admissible evidence, whereas legislative facts can be established through judicial notice and do not require the same level of proof, which I think that's the argument, is Gingras wants it to be legislative facts. And the State Bar wants to say, no, it's adjudicative facts. So the roles in the court is legislative facts assist in shaping legal principles and policies, while adjudicative facts determine the outcome of individual cases. So in conclusion, it says understanding the distinction between legislative and adjudicative facts is crucial for legal reasoning and decision-making in the courts. Legislative facts provide the necessary context for interpreting law, while adjudicative facts focus on the specifics of an individual dispute. The distinction influences how courts collect and evaluate information, impacting the judicial process significantly. So the judge will get to say that whether she wants to say, okay, do I need to take judicial notice of this? Is it going to help me understand the law and how it should be applied here? Which I think is a good argument for Gingras, because he wants the judge to interpret the law in this fashion so that she can legally, by these rules, do this legislative stuff, right? And the bar is like, no, we are talking about the facts of this case, things that he should have done in this case. It has nothing to do with this AI stuff and things like that. So we'll see kind of which way certain things go. I do agree that certain things were not in effect when this case is going on, and that things have changed now. And they can't discipline him for under the rules of 2026. They have to discipline him under the rules back in 2024. I don't know if his standard that he wants to use is wrong or not. Um, I I want to say it has to do with factual stuff and not legislative stuff, but Gingras wants it to be legislative, because that's where he wants to be strong in is case law and cases, and he does want to make things political and things like that. He doesn't want anything based on adjudicative factual scenarios of cases. Because yeah, well, if you have the facts, you argue the facts. If you have the law, you argue the law. If you have nothing, you bang on the table and call people names, which he does often. But that's to me, that's why this disciplinary case is very interesting because while we think he's a pile of shit and he should have done a better job for Laura because he made her life worse. Does that mean legally, sadly, that he did something ethically wrong as a lawyer? We can say he's a shit human being all day long. And we don't think that his behavior should be tolerated. But are there laws and rules in place for what we think right now? Because there's a lot of rules and laws and stuff like that that need to be made about technology, and like they're just now starting to make AI type laws and different things like that where the laws are so far behind on certain things, and even laws for children and victims that after something happens to somebody they love, they have to go put a law in place that you're like, why the hell wasn't this law in place to begin with? Right. It's just whatever. Let him type away. I mean, I think he's a horrible human being, in my opinion. I mean, he thinks I'm a horrible human being. I know that I'm not. But that's, we're allowed to have those opinions. So they are arguing two different things. Um, but that's what's interesting about this case is because I haven't get to seen a disciplinary case necessarily like this. So I think we can learn a lot, at least for Arizona, about things that are going on and what he can and cannot do. I'm interested to see if they say, no, the First Amendment doesn't protect you on this. If the Supreme Court is going to say, no, he shouldn't have been disciplined for this, he should be able to say whatever the hell he wants to say. And then, or if the Supreme Court is going to say, no, you're a lawyer, you need to act accordingly. That's going to be interesting. And if it's not made into law, at least in Arizona or anything as far as with disciplinary, like it's in other forms of law. But as far as attorneys behaving in a certain way, since this anti-slap thing has come into play, now we have to put a law in place. And so will there be a law that says that attorneys can't be disciplined for their words? Because they're technically the disciplinary is considered a government agency. That's what I learned when I was doing some research is that one of the things that we talked about is, well, if McDonald's can fire you for some stuff you said on TikTok or saying certain things, why can't the lawyer and its basically membership thing, organization, why can't that organization say, no, you can't behave like this, you can't talk like that, you're not allowed to besmirch, this, you're making us look bad. And my research was that McDonald's, because they're just a business, they're not like a government thing, that's why they can do it. But things that are attached to a government body, and apparently the state bars are considered part of a government body in a way that they can't do those things. It's very weird. Like when it's yeah, you should not have more or less, to me, more or less First Amendment rights because the feds are your boss compared to a private employer. I don't understand why private employers and feds can't have the same rules. To me, if McDonald's can fire you for things, why can't the bar say absolutely not? No. We don't want you to go here anymore. No, he hasn't won any arguments. And I don't even like to give him the Hey Rob case because basically it was kind of Laura doing most of the stuff and the filings and all that. And Rob's lawyer didn't do anything. And when Gingras made the argument, Gingras' argument was that he wanted more restrictions on Rob. And he lost that argument. So I can't give him the win for him coming in at the last minute to claim victory to be Laura's emotional support pet at court. So she could testify and be the almighty sass queen up there. I can't give him that win, even though technically it is a win because he was the attorney on that day. She was pro se. And his argument that he made, that was solely his argument, didn't end up winning at the end of the day. Did he get attorney's fees? Yes. Nothing what he asked for. Nothing like what he asked for. Could that be the case in Omar's request for attorney's fees against Laura in California too? Yeah. Yep, it could. Apparently, Rob's lawyer is apparently a good lawyer. I still don't know why things went down the way they did, but they did, and it is what it is. I'm just saying I am not going to. To me, it's like if we compare Clayton and Laura's real estate deal, right, to Gingras's coming in at this minute. If Laura had gone through with buying the properties, but she did it with that other real estate person just to sign the paperwork, and it technically on paper would have been that real estate's win. It's not really that real estate's win. It was actually Clayton's because he's the one who did all the work. But that other real estate, because of things, came in and got the contract under his name and things like that. That's kind of how this was. Is some Jingers swooped in at the last moment. Oh no. Okay, I don't know what just happened. Let's see. There's a common thing in football games where if your team wins, sometimes you say, we didn't really win, but the other team really lost. Yeah. It could just be that the other team sucks so bad, that's how you won. And the other team, you could have sucked really bad in that game too, but you just sucked a little less, basically. But it was a bad game because both sides were shitty. No, he's talking about football, not soccer. But yes, Rob's fundraiser is still up, and you can give to him. Dang it. Where did the thingy go? I think. Let me see here. Dang it, I thought it was there. I know it got posted at some point. Where is it? Let's hold on here. It's in his description box, I believe. No, that's Mike's GoFundMe. Okay, I don't know where it is. I don't know where his fundraiser link is. If somebody has Rob's fundraiser link, you can put it in there. No, Laura was never going to buy that property, but I was saying it was just a comparison. Okay, this last document we have is the States Bar brief addressing the applicability of ARS 12751 to lawyer discipline proceedings. Oh, gifts and go. Oh, you can't. Well, if somebody sends it to me, if you can send it to me somewhere, I can post it. So I'm sure it's in a stream somewhere, but I don't know where to search it, and I don't have it quick on hand. I thought it was on Justice this week. Maybe it was on. Maybe it was on All the Best. Oh, here we go. Let me put it here. Thank you, Texas Packet. That is Rob's Gifts and Go. Okay. So we have this. So it says, the State Bar of Arizona by undersigned Bar Council hereby submits this brief addressing the applicability of ARS 12751, Arizona anti-SLAPP statute to lawyer disciplinary proceedings. Footnote 1. Always starting out with a footnote. This brief addresses only the issue set forth in the PDJ's order dated April 30th, 2026, whether the court's supremacy precludes application of ARS 12751 in disciplinary proceedings. It does not address the procedures or requirements set forth in the statute. Okay. So, saying what it is and what it is not. Introduction. To determine whether the anti-SLAPP statute applies in lawyer disciplinary cases, one must first consider the Arizona Supreme Court's jurisdiction over lawyer discipline and the underlying purpose of the rules of professional conduct. Arizona Supreme Court's jurisdiction re lawyer discipline. The Arizona Supreme Court noted its authority over the practice of law as follows. The practice of law is a matter exclusively within the authority of the judiciary. The determination of who shall practice law in Arizona and under what condition is a function placed by the state constitution in this court. Hunt versus Maricopa County Employees, 1980, emphasis added. The Supreme Court's authority to regulate the practice of law is found in Articles 3 and 6. But see this, well, Maricopa County Employees, that's a government. So that wouldn't be like a McDonald's. That's a government body. So Article 3 here says the powers of the government of the state of Arizona shall be divided into 3 separate departments: legislative, executive, and judicial. If you took government classes in high school, which you should have, you know the 3 different branches of the government. And except as provided in this Constitution, such departments shall be separate and distinct, and no one of such departments shall exercise the powers properly belonging to either of the others. Article 6, 1, vests judicial power in an integrated judicial department, while Article 655 states that Arizona Supreme Court has the power to make rules relative to all procedural matters in any court. Based on the Arizona Supreme's constitutional authority over the courts and the practice of law, application of anti-SLAPP statute to lawyer disciplinary proceedings could interfere with the court's exercise of its ultimate authority over the practice of law. For example, the resolution of charges of misconduct may be delayed and otherwise adversely affected if the state's anti-SLAPP statute applies in lawyer discipline proceedings. If the statute applies in disciplinary proceedings, the presiding disciplinary judge, the PDJ, must conduct an evidentiary hearing or consider the parties' pleadings upon receipt of a motion to dismiss premised on the statute, during which all discovery proceeding must be stayed if prima facie evidence is found. ARS 12751E. So the PDJ in Gingras' case was giving him a chance to show that prima facie. But it says the PDJ may, however, grant a motion for discovery for good cause shown. The delay in conducting discovery and the burden associated with the possible presentation of the same evidence at two distinct hearings, one based on anti-SLAPP, motion to dismiss, and the other a hearing on the allegations of misconduct if the respondent lawyer's motion to dismiss is denied. So they're going to have two different like evidentiary hearings for similar things, basically. The state bar investigates and prosecutes charges that lawyers have made disparaging or otherwise inappropriate comments about judges and others. Although lawyers retain First Amendment rights, their free speech right and right to petition the government are restricted. Lawyers do not always enjoy the same rights that non-lawyers enjoy, at least in the context of the practice of law. See Riley versus Arizona. A lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. And I think the problem possibly with the cases that are cited here is the anti-SLAPP is so new. So does the anti-SLAPP come in and wash out all this other stuff about free speech? I would think not. But could some judge or somebody read it that way? I guess they could. I guess there's somebody out there that can think like Gingras. Let's see. Zyman, appeal denied December 4th, 2012. Hearing panel found misconduct based in part on speech. Zyman, 1993, misconduct found based in part on a profane and insulting remark. In Levy of 2022, a December order, Rule 41G, now Rule 42B7, is not merely aspirational. It's not like you should aspire to conducting yourself this way. It means you should conduct yourself in this way. Martinez, 2020, an objective standard is used to determine if demeaning language constitutes unprofessional conduct. And Gagic, a 2023, a December order, misconduct found based in part on unsubstantiated contentions about judges. Statutory construction. A basic tenet of statutory construction is the statute should be construed so as to be constitutional whenever possible. Shannon, 1994, the citation is omitted. The Supreme Court, however, consistently has held the legislator does not have the power to enact laws that would make it impossible or even unreasonably difficult for the judicial department to perform its constitutional function. Generally, both the legislature and the Arizona Supreme Court have constitutional authority to create substantive and procedural legal rights subject to limitations established by the Constitution's separation of power. The legislator is generally responsible for establishing substantive rights, whereas the Supreme Court is generally responsible for establishing procedural rights, citing a case from 2009. To determine whether a statute invades the authority of the Supreme Court, one must first determine whether it creates a substantive right or a procedural right. In the case from 2009, if the statute is substantive, the statute generally prevails. If a statute is procedural but conflicts with the court rule, the rule prevails. It is generally agreed that a substantive law creates, defines, and regulates rights, while a procedural one prescribes the method of enforcing such rights or obtaining redress. Carson v. Gentry, in and for the County of Maricopa, 2025, quoting Allen v. Fisher from Appellate's 1977. So a 25 case quoting something from a 1977 case. Determining whether a statute is procedural or substantive, however, is not always simple. A state procedural rule, though undeniably procedural, in the ordinary sense of the term, may exist to influence substantive outcomes and may in some instances become so bound up with the state-created right or remedy that it defies the scope of the substantive right or remedy. Let's see here. Internal citation marks omitted. In addressing that issue, the Arizona Court of Appeals has stated the statute creates a procedural rule, does not automatically render it invalid as a violation of separation of power provision, as our Supreme Court noted. The legislator may enact procedural rules so long as they merely supplement but do not contradict existing court-made rules. It is the role of the courts to review a legislative created rule to determine whether it meets the tests of enunciated in Seidel or conversely impermissible infringes on constitutional power vested in our Supreme Court. They cite another case. Hello. Yes, this is the Taliban where we make hostage videos. I tried to get Lauren to be the Taliban and leader and I be the cult leader. She turned me down. Which, considering what happened September 11th, I don't blame her. But so she's a cult leader. I would rather much be in a cult than a Taliban, but But hello to all Lethal Lauren's people and to the bacon people. Did he say something? I think he's just joking. I don't know. Okay. So, Arizona's anti-SLAPP statute, ARS 12751. Y'all can block who y'all want. I don't care. Arizona's anti-SLAPP statute establishes a procedure to promptly address whether a legal action is substantially motivated by the desire to deter, retaliate against, or prevent a lawful exercise of constitutional rights. ARS 12751A and B emphasis added. The procedure will ultimately, I cannot read tonight, ultimately result in a finding whether a legal action was brought up for improper purpose. Blah, 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 blah. Because they cannot talk. Although the two branches of government have generally distinct purposes, even if that statute were to be found to be excessively procedural, the Supreme Court will enforce it if it is reasonable and workable and does not conflict with the court rules. Citing cases from 2020. Okay. We will recognize reasonable and workable procedural laws if they supplement rather than conflict with court procedures. The Arizona court could alternatively determine that the anti-SLAPP statute provides substantive rights to litigants. For example, the Arizona Supreme Court may defer to legislation regarding procedural matters that promote substantial goals of public policy. Supreme Court deferred to legislative pertaining to relevant evidence that promoted substantive goals of public policy, such as an accident prevention. The statute's inclusion of the language authorizing the recovery of cost and reasonable attorney's fees may also be deemed to create a substantive right. Furthermore, the statute may also create a substantive right because it provides a procedure for citizens to promptly prevent forced litigation of a non-meritorious case, which could result in the expenditure of time and money. Yeah, Laura knows how to do non-meritorious cases that result in an expenditure of time and money. When determining whether a statute is procedural or substantive, the Supreme Court looks at the true function of the statute at issue rather than relying on labels. Ew, labels. At least one court has found that an anti SLAPP statute was a hybrid procedural slash substantive law. That was in Utah in 2015. The public policy underlining the anti SLAPP statute is simple. Well, it doesn't seem so simple based on this filing. Ensuring that citizens and residents may assert their constitutional rights without fear of retaliation through the courts. Yes. The question becomes whether the Arizona anti-SLAPP statute usurps the court's rulemaking authority and violates the separation of power doctrine if it were to be applied in lawyer disciplinary cases. Which it's always interesting because, I mean, there's checks and balances, but if attorneys wanted to get away with certain things, but granted, the people that are in power of making certain laws are not always attorneys. Some of them are, but couldn't like attorneys like David Gingras, you know, if he were up in the legislative branch, couldn't he just make a law or have people like sign off on something that lets attorneys just get away with whatever the hell they want to so that they can't just be disciplined ever, you know? Not that they should be allowed to do that because that's why there are checks and balances, but I mean, this makes it seem like Gingras should not ever be able to be disciplined for a damn thing that he does. Um, Other jurisdictions' determinations whether anti-SLAPP laws create procedural or substantive rights. Okay. Yeah, there are Yelp reviews. There is. I have Yelp reviews as well. Some are great, some are not. Google reviews, all that. Like, it doesn't mean a certain thing. Everybody's gonna have certain good and bad. So you can't just base it off of just that. It's okay, Lauren. Yeah, but you're not you can disagree with that all you want. It that um doesn't mean a judge is gonna disagree. And prepping for certain things is expensive. Getting certain things is expensive. It could be that the judge says, "No, Omar, this is too expensive." But that's up to a judge. It's not up to us. And people didn't just donate to Maricini for just legal stuff. Yes, does it go to attorney's fees and stuff? Yes. But we also know it can go to other things. Doesn't mean all of it's just going to him. But the review thing is not a great argument for me. Um, but we wait and see what the judge says. We don't get to police that stuff. If you don't want to um, support that, that's fine. And I don't have a problem with you saying you don't support it. I don't have a problem with you asking questions. And you know that. But I don't want chaos to ensue in the chat. Some reviews, some people, and they may not. Just like Gingras asked for a bunch of fees too, and he didn't get awarded those. So it could be the same thing. Not everybody is as lucky. I mean, look at Afro Man. He was told nobody's giving him, nobody's covering his attorney fees, and he won a case. And he has to pay his own shit. That's for the judge and the appeals court and everything. That's not for us. You donate because you want to donate and support a cause. That's it. Don't donate if you don't want to support it. And you don't have to like them. But that's not even what we're not even discussing any of that right now. And we'll see what happens. But back to procedural and substantive rights. There is a lack of consensus among courts whether anti-SLAPP laws are primarily procedure, substantive, or a combination of both. While courts have split in determining whether anti-SLAPP laws primarily provide substantive rights or procedural rights, all have to have at least one procedural element establishing an expedited procedure to resolve whether a lawsuit has filed primarily in an effort to quash a defendant's constitutional rights. The Second Court of Appeals has found that a statute's anti-SLAPP statute provided substantive protections. See footnote 2. They're allowed to keep the peace of their own lives if they, however they see fit. So that one's just a holding that Nevada's anti-SLAPP law provided substantive rights. Okay, so that one's that one. The 10th Circuit has found that the state's anti-SLAPP statute was procedural and therefore conflicted with federal rules of civil procedure 3, or see footnote 3. Plain language of the New Mexico anti-SLAPP statute reveals the law is nothing more than a procedural mechanism designed to expedite the disposal of frivolous lawsuits aimed at threatening free speech rights. Noting the D.C. Court of Appeals found that its statute established a new procedural mechanism for dismissing certain cases before trial. Right. And other circuits and D.C. courts of appeals have found the anti-SLAPP statute includes substantive or procedural rights depending on the law under review. Footnote 4. It's just saying it's both. But I can see it as a good thing, like people trying to sue you for stupid shit, and they're just trying to sue you and make you lose money, and you can get that case knocked down. I think that's a good thing. I think it can be both, depending on circumstances. There is also a lack of consensus among state courts whether anti-SLAPP laws primarily establish substantive or procedural rights. Kentucky, Maine have held that anti-SLAPP statutes provide procedural rights, whereas Connecticut, Oklahoma have held state's anti-SLAPP statute created substantive rights. Georgia, on the other hand, has determined that its anti-SLAPP law is both procedural and substantive in nature. I don't see Arizona being mentioned in what they have decided. So let's look at these footnotes. Finding Georgia's anti-SLAPP statute procedural and created no substantive rights. Holding the District of Columbia statute provided substantive rights and stating that the substantive/procedural distinction was of minimal relevance, although it's previously found the statute provided a procedural mechanism, which to me just means it's a way out of not going forward on a case. Like, so substantive law defines the rights and duties of an individual and organization, outlining what is legal and illegal, as well as the rights and responsibilities of people. Procedural law, on the other hand, outlines the process and rules for enforcing those rights and duties, detailing how legal cases are handled in court. For example, substantive law would define like a crime like a murder, while procedural law would dictate how the trial was conducted. They're both essential for well-functioning legal systems and making sure things are done right. Procedural laws are applicable in non-legal contexts where substantive laws are not. So procedural just outlines steps to get to certain things. It's exactly. Maricini has spent money in the past on it. And people can do what they want to do on their channels, just like people can kick you out of a restaurant if they don't want you there. Snow, don't. Rob is getting back on certain things, and Rob and I are working really hard in the background, researching a case for y'all that we are excited. We are waiting on certain things so that we can bring it to y'all. And it is still out of Arizona. Okay. And I don't think people should, if you haven't actually been a client of somebody's, I don't think you should go leave a review. Like in the Depp trial, like a bunch of people with that Dr. I don't know, Dr. Spock, whatever his name was, went and left a bunch of horrible Google reviews and stuff on that because he testified in the Depp trial against Depp. A bunch of people went and like gave him a lot of bad like reviews. Just like I don't think that people even should go to Gingras' site and give bad reviews. Because if you Rob could, he's had to deal with him. Dave could. Omar, Rachel, maybe they could have things. And if Lauren was ever served with anything, Lauren could do certain things. But if you haven't dealt with them real world as your lawyer or something like that, people don't need to go do that. You just shouldn't. Whether you don't agree with them or you do. I would never go leave. I would never go leave. I would never leave Gingras a bad law review being like, "Don't hire this lawyer." Um, that was just not something that I would do because did you do it for an actual case to hire Eagle Law, or did you do it for a research purpose to see if those reviews were accurate or not? Um, a lot of people, like with the Karen Reed case, if you haven't gone to D&E Pizza, just because you don't like the Alberts, you shouldn't go on there and say, "Oh, this pizza sucks, the owner sucks." You haven't had their pizza. If you have a problem, try to handle it within the thing instead of going out there and leaving bad reviews. Just like even some like DoorDash people, it it if you like certain DoorDash people, they wanna leave a bad review and they get in trouble, and that's their lifeline, because people just want to lie or say bad things. You wanna leave a review because somebody forgot to give you some ranch or something, like, and then they lose their job and all that over some of that just because certain people like, there's ways to handle things, but anyways, enough off track. Okay. The substantive rights and stating the substantial procedural distinction was of minimal relevance, although it's previously found the statute provided a procedural mechanism and did not conflict with the district summary judgment rule and was therefore lawfully enacted. And then this Davenport one statute falls squarely in the procedural category. They provide procedures that permit expedited consideration of already existing substantive protections. Let's see. Maine's anti-SLAPP statute is a procedural mechanism to screen meritless cases and does not change the common law regarding the underlying claim of defamation. It doesn't. That is true. It does not change it doesn't change whether something is defamatory or not. It just is like, do we want to go further with this or is this just really ridiculous? Being like, "Oh, somebody called me a see you next Tuesday." A and they wanna sue you for that. That and anti-SLAPP's gonna be like, "No, we're not going through with this claim. We're not wasting the court's time with this." But if you have a bunch of other shit that says things, okay. I still don't think Gingers should win on the way he was behaving because he can't take it out of the filing. If he wants to argue that the shit he said in his blog was fine and free speech, all this shit, fine. But he cannot take the crap about "look at me, daddy" out of his filing. That is unethical, and it was bullshit. That is not free speech. You do not have free speech there. You don't get to just say whatever the hell you want to and stuff. You also can get in trouble and get contempt charges if you just start going off on a judge in a courtroom. And to me, by putting it in a filing, that's inside the the courtroom. So the judge could be like, "You know what? We'll take away the stuff you wrote on your blog." Even though it's your law blog. Maybe he should open a personal blog up and not have it on his law website. But when you put it in a filing, that's a different thing. Had he never put something in filing, maybe I could be like, okay, whatever. He can say whatever he wants. I still don't think it's ethically right that he's doing that with nothing to back it. And I don't think he should go to jail for any of it. Should he lose his law license? Absolutely, in my opinion, or at least get in trouble for it. Smith v. Supple, that's not a word I wanted to say today. A Connecticut case from 2023 that said the anti-SLAPP statute affords a defendant substantive rights to avoid litigation on merits that can be costly and burdensome. I don't think things that Gingras has to say has merit, but that's just me. Let's see. Oklahoma, while there is no doubt and such mechanisms are procedural, they affect a substantive right. Footnote omitted. Let's see. Atlanta Humane Society. The verification requirements of anti-SLAPP statute is procedural in nature, in that verifications must contain certain assertions and must be filed with a certain time, but is also substantive in nature, in that to determine whether the requirements of the statute have been met, the court must take a substantive look at the verification offered to ensure that the underlying lawsuit has not been initiated for improper purpose. And if that's what he's trying to say, is that this bar complaint or these bar charges are brought for an improper purpose, you're not going to win on that. I think that's a weak argument because I don't think they can prove. He can't prove that the bar did this retaliatory or for an improper purpose. They did it because they thought you were misbehaving. Conclusion. It is unclear whether Arizona's anti-SLAPP statute is simple, procedural, or substantive. However, any application of the statute to lawyer disciplinary proceedings would be inappropriate because it invades the authority of the Supreme Court and may be prejudicial to the court's administration of practice of law and enforcement of rules of professional conduct due to possible delay and duplication of hearings. Also, ARS 12751 applies only to a person's lawful exercise of rights of free speech and petition. As noted above, the Arizona Supreme Court has, at least indirectly, found that lawyers have a limited right to free speech. As a result, respondents may not argue that he was exercising a lawful free speech right. Although PDJ could decide whether Arizona's anti-SLAPP statute applies in the lawyer's disciplinary case, the PDJ could avoid addressing that issue by assuming the statute applies, but the respondent has not provided prima facie proof that the state bar's complaint against him was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. See footnote 10. Harkins versus Atlanta Humane Society. Again, in the matter of the disciplinary of attorney, Mass 2024, the Massachusetts Supreme Court avoided resolving whether its statute applied to lawyer disciplinary proceedings, stating, assuming, without deciding, both that the respondent's conduct was protected petitioning activity within the meaning of the statute and that the anti-SLAPP statute applies to bar discipline cases, we nevertheless conclude that the respondent has failed to show that bar counsel lacked a substantial basis other than or in addition to petitioning activity or bringing this action. The court further stated in a footnote, we decline to construe this anti-SLAPP right so as to immunize every written or oral statement made by an attorney in connection with an issue being litigated. Okay. Ah, where did it go? Okay, so that's that one signed. Oh, in a civil suit because such broad reading would preclude enforcement of many attorney conduct rules. Um, yeah, I agree with that last part. I just feel like it's like saying, well, we can't be disciplined for anything. And it just doesn't make sense. I don't know how you would personally know that, Israel. Um, as far as where they stayed and stuff like that. I mean, they'll have to show if the judge wants to see proof, he'll be shown proof or she'll be shown proof. It's not for us to do. What we do is we just watch and see what courts do. We give our opinions on things that are happening. But I don't subscribe to like I don't want to deal with gossip on this stuff. But so that is the stuff that is happening in this. I still don't think that anything that's been filed right now, I don't remember if Dingus was given a date. Well, hello, Jen, the couch fairy, of when he needed to provide this prima facie thing, showing that it's retaliation and certain things like that. But it's got to be coming. But so far, I don't see where he just gets this dismissed. But who knows? Jingers could be right about things. Um, People can be right about certain things. Uh, he can be right once in a while. This would be almost the first time he was right about certain things because he didn't even come up with some of this shit on his own. Like his judicial notice shit is because of Patrick and Bruce because it suited him. Mm. All right. So, yep, broken clocks right twice a day. Substance substantive substantial substantiative. I like Justice trying to help me figure out words. All right. I believe that is it. Bacon Bears had a good stream today. Flux. What what was hers yesterday that I didn't when was hers? Ah, no, hers was today. Flux had a good stream today as well. Y'all could go check it out. And we'll continue to see what happens in Gingras's disciplinary case and what happens in Laura Owens' cases. because they don't stop. And we'll be here reporting on it for everything. I think she is dumb if she does not take this plea deal. But can she admit guilt? And Bacon Bears brings up Sherry Papini. The thing with Papini is she did plead guilty and she went to jail. The thing that's the thing. And then Sherry Papini goes around and tells a different story. I was thinking, I don't know why she did plead. But now she says different things. Yeah, she shouldn't be allowed to come out and do that. And will Laura do that? I think even if Laura was sentenced, and she was just found guilty, she can continue saying it was the cult's fault and they were prejudiced and the jury was corrupt and all this other shit. And she could continue to say that she is still telling the truth. And like many people that go to jail or prison, even if they kill people, will maintain their innocence. Like Lori Vallow says she had nothing to do with any of that shit. No, I don't care how long she claims her innocence. She's guilty. But other people like Sean Ellis, he was innocent. And some people that are exonerated, that were wrongfully convicted, that's different. I don't think anything will ever come up that shows that Laura Owens would be wrongfully convicted. Because if she had it, she would have already proven it. Because if Laura came out with some stuff and was like, see, here's the proof, the prosecution, Rachel Mitchell, should dismiss the case if Laura just all of a sudden now came out with proof that was not a pea stick. And she doesn't. There is no proof for any of this shit. Because why, if you had proof and you had things, oh, well, I thought it was my privacy. This is when you say, fuck my privacy. I wanted to keep certain things private. But this is where you say, you know what? I don't give a fuck about my privacy. I don't want to fucking go to jail. Because I am telling the truth. Here is all the proof, all of it. You can see all of the shit. I don't care who knows. That's not happening. You can get blocked from people who don't like you. Certain people have a personal bond, certain protection. They do certain things. And I don't think they have a problem with you questioning things. It's when you start talking about like gossip. And all that people did was say, here is a GoFundMe. You can donate if you would like. And people can choose whether or not to do it. I put up Rob's GoFundMe. That doesn't mean that I am forcing people to go donate. If Rob, for some reason, goes above one day his limit that is over over the amount that he asks for, they can do that. But it's not a cult. We don't have people saying this. We don't force people into thinking the same things. And who knows if a California appeal is unnecessary or not? She's appealing it. So that would be necessary. And nobody is forced to donate. Some people physically cannot donate money. You can question the billing. That's fine. But there's ways that you can go at it. You can say, I don't agree with the billing. I think the billing is too high. That is perfectly fine. And Mike has also said that if he has over a certain amount, he will also donate it to something. And I don't even care if he donates it or keeps it all for himself. But to me, there's pain and suffering that goes with Maricini and all these victims. And Omar will get what the judge says he gets, basically. And it's out of our hands. And at least Mike has transparency with this is how much this money has gone for. Can't say the same about Owens. Most people do file it because you do not want them to get the appeal. Just like if somebody is found guilty, the state still responds because somebody was found guilty. They don't want Laura's appeal to win, so they are probably going to say something. Yes, and only 50,000, I believe, has gone towards bills. It's not everything. And people know now that the money right now could just go to him. He's going to have to find a new attorney. Okay, Omar got 20K. Well, yeah, because then there's the court reporters and all that. That money is not sent. That money is not for Omar. That's for those people. The court reporters, certain things, they go to certain costs. But I said, that's not for me. Okay, so yeah, there's Rachel as well. Behind the scenes shit. A lot of people who are not making anything off of it. I basically do this for free. But I have created, let me show y'all. I have created a membership mascot. I don't know if I gotta figure something out. Where's our membership mascot? Here is our membership mascot. Yeah, got him made today. Anywho, let's close this out. And I hope everybody has a good evening, good night, good day, afternoon, weekend, whenever you're watching this. And I will see you in the next one. Bye, guys. It's been a long day.